Hello friends, this is the fourth video on law of evidence, and in this video we are going to study section 3 of Indian Evidence Act. Friends, section 3 of Indian Evidence Act is an interpretation clause. It states that in this act the following words and expressions are used in following senses unless a contrary intention appears from the context. So section 3 basically gives a meaning of certain words which are to be used in the Indian Evidence Act. And it says that unless and until the context gives a contrary meaning, the word are to be used in the following sense. Now, it is important to note that unless a contrary intention appears from the context, that is, it says that the general meaning will be as given under this section. However, the text, the famous quote which says that text should be read in light of the context, has also been emphasized in section 3 of the Indian Evidence Act. In this section, there are 10 definitions which are being provided. One is quote, thereafter fact, third is relevant. Remember friends, the word relevant has been defined. Meaning of word relevant has been given, not the meaning of word relevant fact. So many a times in prelims examination, it has been asked that section 3 of Indian Evidence Act gives meaning of quote, fact, relevant fact. And many a times a student confuse between relevant fact and relevant. Then the fourth is fact in issue, that has also been explained. Fifth is documents. Six, evidence. Seven, proved. Eight, disproved. Nine, not proved. 10, India. So these are the 10 things which have been explained under section 3 of the Indian Evidence Act. In this present video, we will be dealing with the first 5, and in the next video we will be dealing with the next 5. This is done so as to avoid a long video session which can cause monotony. So let us start with the first word that has been explained in section 3. The first word is court, and it states court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. So friends, the word court as far as Indian Evidence Act is concerned includes 3 things. One, judges. Second, magistrates. And third, all those persons who are legally authorized to take evidence. This is the inclusive one. And it also excludes one category from that of court, and that exclusion is that of arbitrators. Now, the first thing is the definition exhaustive in nature? Does it contain the full and the complete meaning of the word court? The answer is no. The word court has not been exhaustively explained in section 3. It only states certain category who are included and certain category who are excluded. Then another thing is that does the court include jury? You know that there is a system of jury in many countries where the court is assisted by certain persons from the society in making the decision. Then it is stated that yes, the court includes the word jury as such. And third, which is very important from the point of view of examination, and many a times in preliminary examination it has been asked, does the court include arbitrator? As we have seen that section 3 specifically includes judges, magistrates, and all persons authorized to take evidence, but it excludes arbitrators. So we will say that, does court include arbitrators? No, the court does not include arbitrators as far as section 3 of Indian Evidence Act is concerned. So this was about court. Next word which has been explained is that of fact. And this is very important from the point of view of prelims as well as mains examination, because many a times they have given to write short notes on the fact. Now what should be included, what should be written in it, we will see later on. First of all, let us go through the bare provisions that is given. So it states fact means and includes. Remember, friends, that in the quote it was that quote inclusive definition is there, includes, while in fact it is written that it means and includes. What all? Anything, state of thing, or relation of thing capable of being perceived by senses. So anything, state of thing, relation of thing that can be perceived by our five senses are fact. So these are physical facts. While second says that any mental condition of which any person is conscious of. Now this is what is called the mental element, the psychological facts. Now, they have given certain examples to it, illustrations. And my dear friends, these illustrations are very important because many a times question has been asked based on the illustration. So what it says is that there are certain objects arranged in certain order in a certain place is a fact. Certain objects arranged in certain order in a certain place is fact. That a man heard or saw something is a fact. That a man said certain word is a fact. Now all these three are physical in nature. Then D says that a person holds certain opinion, has certain intention, acts in good faith or fraudulently, or uses particular word in a particular sense, or is what or was at a specified time conscious of a particular sensation is a fact. Now this is the mental aspect or the psychological fact as such. Then that a man has certain reputation is a fact. Now we will just see as to what all we should write when we are writing a short note on it. Now fact has been categorized into two. One is external facts, those which can be perceived by our senses. These are physical in nature. And another is internal facts, those which a person is conscious of. And these are mental in nature or psychological in nature. Another category of fact are that facts may be positive or fact may be negative. Now, positive facts are those facts which gives a indication of existence of a thing, while negative facts are those which gives the indication of non-existence of a particular thing. So facts may be further classified into positive facts or negative facts. Positive facts are those facts which gives an indication as to existence of certain thing, while negative facts are those facts which give an indication as to non-existence of certain things. Then another very important thing is that facts may be classified into factum probandum and factum probans. Factum probandum are the principal facts, the facts which are necessary for giving judgment. while factum probans are evidentiary facts, the facts through which the fact in issue, the principal facts, are to be proved. So we see that facts can be factum probandum, that is the principal fact, or fact can be factum probanus, that is evidentiary fact, the facts through which the factum probandum are to be proved. Now, one very important part is that how psychological facts or mental facts, or as we saw, facts of which person is conscious of, is to be proved. Now, they are proved through circumstantial evidences. So that a man has a particular intention, that a man acted fraudulently, these all things, that a man had got good faith, are proved by circumstantial evidence, as there cannot be direct evidence of these things. Now, I will just give an example of what kind of questions may be asked in your examination. So they may say, a state of man's mind is as much a fact as the state of his digestion. Explain. So here they are saying the state of man's mind, that is, they are referring to the mental aspect, the psychological facts, is as much a fact as the state of his digestion. This they are referring to the physical aspect. So here you have to explain what is fact and what are the two types of facts. Now another thing is which has been given under section 3 is the word relevant. My dear friends, I will again say that word relevant has been given, not the word relevant fact. And what it says that one fact is said to be relevant to another when one is connected with the other in any of the ways referred to in the provision of this act relating to relevancy of facts. Friends, we will explain it, as many a time short notes is asked on this also. And what all points we have to include, we will see, because many a times we know the definition, but we do not know what is to be included in writing the short notes on it. So first, there are three things which we will write in it. One is definition of it, another is the type of relationships, and third is the importance of the word relevant. So now definition, a simple definition of word relevant will be that it is the thing which have a relationship, thing which is linked to another fact, a fact which is linked to another fact. And this linkage, this relationship may be logical relationship or it may be a legal relationship. Now, it is to be understood that all logically relevant facts are not admissible, but all legally relevant facts are admissible. Now, what type of relationships are contained as far as relevant is concerned? One is that the fact may be logically connected with the fact in issue. For example, that the fact may be connected in the way that it is a type of motive, or it may be conduct, or it may be preparation. For example, if we say that the A killed B, now the relevant fact would be that was there a motive for A to kill B? Was there a preparation by way of buying gun by A to kill B? And what was the conduct of A after B was killed by him? So these facts are logically connected with the fact in issue. Another is that by way of admissions and confessions. We will see it in our later sections that how these words are used. Next is that a statement by non-witnesses. Sometimes statements by non-witnesses are also relevant. For example, dying declaration. Then a statement made under special circumstances. For example, the statement which is recorded by a public officer while carrying out a public duty in normal course will be relevant. The entries made by a police officer in daily diary will be relevant. Next is that judgment in other cases. Then opinions of third persons are also relevant certain time. For example, expert evidences are relevant under Act. Then evidence as to character are also relevant. Now, what is the importance of this word relevant? The importance is that relevant facts acts as evidence or evidentiary have evidentiary values that proves a fact in issue. So once fact in issue is proved, then we can give judgment on it. So we saw that relevant, what does the word relevant means? That it has got a linkage with one fact has got a linkage with the other. There is a relationship logically or legally. Now, the types of relationship, we say that they may be logically connected, it may be by admission or confession, by non witnesses, special circumstances, judgments, by experts, or as to character. And importance is that it leads to the proving of fact in issues, which leads to judgment. Now, another important point is fact in issue. Short notes are asked on this also in many examinations. So first of all, we will go through the bare act and then we will explain it. Section 1, chapter 1, section 3 states the expression fact in issue means and includes. See, it is again means and includes any fact from which either itself or in connection with other fact the existence, non-existence, nature or extent of any right, liability, disability is asserted or denied in any suit or proceeding necessarily follows. And it has got an explanation. Whenever under the provision of the law for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in answer to such issue is a fact in issue. Now, it has also got an illustration, and my dear friends, I will again say that illustrations are important because they are asked in examination. A is accused of murder of B. At his trial, the following facts may be in issue: that A caused B's death. A intended to cause B's death. A had received grave and sudden provocation from B. At the time of doing the act which caused B's death, A was, by reason of unsoundness of mind, incapable of knowing its nature. Now we will one by one see that what is fact in issue. Now, as far as this definitional aspect is there, so fact in issue means fact in dispute, the factum probandum, the facts which are to be proved as such. Now, what the section 3 says is that facts which are asserted by one and denied by the other. That is, if plaintiff asserts it, the defendant denies it. If the prosecution asserts it, the defense denies it. And vice versa. That is, if the defendant asserts it, plaintiff denies it. If the defense asserts it, the prosecution denies it. So things which are asserted by one party and things which are denied by the other party. Now, what these things asserted by one, denied by other regarding existence, non existence, nature, extent. of any right, liability, or disability in any suit or proceedings. So, if we give a basic definition, then things which are asserted by one party and denied by another party. And it is relating to existence, non existence, nature, extent of any right, liability, or disability in any suit or proceeding is what is fact in issue. Basically speaking, fact in issue is a fact in dispute. Now, how do we determine the fact in issue? What are the factors through which we determine that this is the fact in issue? Now, there are two important things through which fact in issue is to be determined. One is the provisions of substantive law, and another is assertion and denial by the parties. For example, if we say that between A and B, A claims that B has committed the tort of negligence. Now, in this case, there is, suppose for negligence, there are three substantive things to be proved. That one, there was a duty to care. Another is that duty has not been performed and this led to damage. Now, these are the substantive provisions. Suppose A asserts that there is a negligence on part of B, and it states that B had a duty to take care, and B did not perform that duty. As a result, there was a damage caused to A. Now B agrees that there was a duty to care, but B does not agree that there was that the care was not taken by him. So now this would be the fact in issue. So why? Because the substantive law says these three things, and the assertions and the denial by the parties says the part two of it. So the fact in issue will be that though there was a duty to care between A and B, yet that duty of care was not done by B. So, how do we determine fact in issue? Fact in issue is determined by the substantive laws and the assertions and denial by the party. In criminal proceedings, the charge sheet is an important fact through which, or an important thing through which fact in issue is determined. In civil law, the pleading of the parties. In civil proceedings, the pleading of the parties in form of the plaint and in form of the written statement. That is what which forms the fact in issue. Another thing is that fact in issue as given in Evidence Act is same to the issue of fact terminology which is used in Civil Procedure Code. Now, what is the importance of fact in issue? The importance of fact in issue is that this is what which is the main point of dispute between parties. So proving it will help us in giving the judgment. So judgment will depend upon the facts, proving of the facts in issues. So if we are given to write about fact in issue, we have to write the definition of it, where it says that fact in issues are fact in disputes which are asserted by one, denied by another, relating to any right, liability, or disability. And how do we determine fact in issue? We determine fact in issue by use of substantive law and by the assertions and denial by the parties. And its importance is that this is the basis on which the judgment is to be given. Now, let us talk about the next term, which is very important, and many a times in prelims examination it is also asked. The word document, and states document means any matter expressed or described upon any substance. Any matter expressed or described upon any substance by means of letters, figures, marks, or or by more than one of those. Once in Haryana civil judiciary examination, they have asked that the words document can be engraved by letters A, B, figures C, marks D, alphabets. Then it has been clearly explained that here the word letter, figure, or marks are what is mentioned in the act. Now, any of these means, and what is intended to it? Intended is that for purpose of recording. Now there are certain illustrations, and these illustrations are also important as they are also asked in examination. A writing is a document. Word printed, lithographed, or photographed are document. Map or plan is a document. Inscription on metal plate or stone is a document. A caricature is a document. So, document means that on any substance where through letter, figures, and marks something is expressed or described, and the idea or the intention behind it is recording of it. So, any matter which is expressed or described through letters, figures, or marks on any substance and used for the purpose of recording is a document. Now, the definition which is contained in the Indian Evidence Act is similar to one that is contained in the Indian Penal Code. Now, if we broadly classify the documents, they can be classified as electronic or non-electronic documents. So friends, this is the 5 definitions which we are to see in this video, and we will just give a quick recap of the whole provisions. One is that section 3 is the interpretation clause, and it gives the meaning of certain words. 10 words have been included in it. The word court includes all judges, magistrates, and persons legally authorized to take evidence. However, it does not include arbitrators. The definition is not exhaustive. Jury are included under the word court. However, arbitrators are not included. As far as the word fact is concerned, it means and includes any fact, state of things, relation of things that is capable of being perceived by our senses. Then it consists of also mental condition of which a person is conscious of. It can be of two types, external or internal. External, that gives a physical appearance. Internal, that has got a mental element in it. It may be a positive fact or a negative fact. Positive are those which leads to existence. Negative are those which leads to non-existence. Then it can be factum probandum or factum probanus. Factum probandum are principal facts, while factum probanus are evidentiary facts. The psychological facts can be proved through circumstantial evidence. Now, the word relevant has also been explained, and it says that one word is relevant to another if it is connected in the way referred to the provision of this act. Relevant means that there is a linkage, there is a relationship. It may be logical as well as legal, and there are broadly these kinds of linkage. They may be logically connected through admission or and confession by non-witnesses in certain conditions, under certain special circumstances, judgments in certain cases, opinion of experts, and as to character. And they are important because that is what which leads to the proving of facts in issues. Then we come to fact in issue. Fact in issue means and includes. What does it means and includes? That things which are asserted by one party and denied by the other party. It should be related to their right, liability, disability, where their existence, non-existence, nature, or extent is involved. Now, fact in issues, how they are determined? They are determined by the substantive law, as well as the assertions and denials of the parties. Importance of fact in issue is that judgment is based on it. Documents. Documents are anything or any matter which is expressed or described by means of letters, figures, or marks on any substance, and the purpose of which, the intention of which, is to record it. And the definition which is contained in Indian Penal Code is same as that which is given under this section 3 of the Indian Evidence Act. Then there are two types of documents, electronic and non-electronic. That's all. Thank you.